Our next case is Gormley versus Gormley. Each party will have 15 minutes to present the argument. Appellant, you may have reserve up to 5 minutes for rebuttal. You know how long you'd like to reserve?
5, Your Honor.
All right, very good. I will be keeping the time up here, and you will not be able to see it, so when you get about a minute left in your initial time, I'll give you a 1-minute warning. Pardon that interruption in advance when I do that. I will not give you the warning in your rebuttal time. Okay. If you go a little bit over, we'll just take it off your rebuttal time. If we talk for 11 minutes, we'll have 4 minutes of rebuttal time left. Okay. We'll give you that warning. And counsel, I will try to let you, I'll try to let you know when you have about 1 minute left in your time too, give you that same courtesy to know where you're at on the clock if you get to that point. The arguments are being recorded, so when you come up, first of all, please introduce yourself. Please stay behind the podium because we're visually recording you, and that way we can hear you. We also speak loud enough so we can hear you. You should not use the name of a child, minor, or victim. I don't know if we have one in this case. Really, I think that the children are all adults. We shouldn't refer to any children anyway. But if you would, please use an initial or a term like the child or a victim. With that, the court's read your brief and are ready to proceed whenever you are.
Good morning. My name is Charles Tyler Sr., and I represent the appellate in this matter. This matter came up for trial in Medina County Court January 9th of 2024. The husband and wife testified at the trial. Wife testified that she's employed in Akron Public Schools as an art teacher. Testified that her gross pay for 2023 was $89,749.77. She testified that part of that was for extra work called supplementals. In addition, she testified that she has mandatory contributions from STRS in the amount of $12,511.02. Her disposable income is $77,238.75. Her husband's income at the time of trial was $125,000. The trial court awarded her $250 in spouse support. One of the things the trial court used as part of her income was a $600 a month student loan payment that she no longer had to pay because she received public service loan forgiveness. There's no statutory language or case law that says that student loan forgiveness should be counted as income for purposes of spousal support.
How do you know the court counted it?
It says it in the transcript, it's in the order.
In the order, it just talks about it. It doesn't necessarily conclusively say that's what was considered as part of the income.
That is true, Your Honor, but it was the court's job that the law requires that if the court is going to use something other than what's on the W-2s and tax returns, it's the court's responsibility to explicitly state why they use it and why. So it's not really Mrs. Gillies' job to even interpret what the court intended or how they used it. To say that that's income, truth of the matter, my client didn't pay for the loan forgiveness or her ex-husband. Taxpayers did that. That's like standing in a child support hearing and a dad argued she got a welfare check, I should be given credit for that. No, taxpayers took care of your kid, and it was taxpayers who provided for loan forgiveness. It's not income of either of those parties. Further, the law does not provide that anyone who gets those forgiveness have to pay income tax on that. So the court, in using that, is creating its own law that doesn't say that that's income.
Tyler, did the trial court use any fin plans or things like that are part of the record? I don't see one attached to trial court decision.
Did not use the fin plan, did not talk about equalization of income when my client makes less than $80,000, husband makes $125,000. The trial court even said in their calculation for child support, they took into consideration that the family could not go on vacations because appellant was paying a $600 student loan payment. Again, the statutory language is not there to support the trial court using somebody can't go on vacations as a part of your calculations. In this district, it's been said that in case law, Pelosi, I think is the case, that you don't give a reduction in spousal because you're considering what they got in another property division. I know there's split in circuits, but over here in this district, they said that you don't do that. This court in this situation did that. We think that the court lost its way in considering the student loan payment as part of the income calculations, lack of vacation as part of income calculations, and we think that it should be reversed. It's a long-term marriage. The parties been married 23 years. That should have been taken into consideration. The appellee testified that there was times during their marriage that the appellate didn't work. Well, he was able to continue to practice as a law while she stayed home to take care of the kids, allowing him to progress in his career. She started working late because she stayed home as a good mom and took care of the kids. And now it's time at divorce, she's being penalized for having less years of income when she stayed home to take care of the kids. It was his own testimony that testified that there were times during the marriage that the appellant did not work.
At the trial court level, did your client have a request for spousal support or file any exhibit kind of breaking down their expenses and say, here's what I think ought to be a reasonable amount of support?
That is correct. In fact, Your Honor, the only issues that was tried in the trial court was spousal support and division of property. No other issues was tried.
What did your client at the trial court level ask for spousal support? What did she think was fair and appropriate?
$2,300. In the beginning of this case, first she was awarded temporary support in the amount of $2,000, and then that magistrate retired. Another magistrate looked at the objection, and it was reduced down to $250. Then at the trial court, they kept it at $250.
So magistrate made it $250. Did she move to set that aside or anything during the case?
She did.
And did the court rule on that before trial?
They did not.
Okay.
Yeah.
And I haven't seen the whole record, so I apologize. Thank you.
No problem, Your Honor. Then, when we first filed the appeal, this court said it wasn't a final appeal order and sent it back to the trial court. And when it came back in the trial court decision, they had awarded a vehicle to an adult daughter. And I think it's very clear the court is without jurisdiction to award marital property to a third party. Number one, who's not a party to the case, and number two is an adult child of the parties.
Well, the other side is saying that that was all stipulated to, that was all part of an agreement.
Well, the court has the transcript, and the court will see that that is not in the transcript where that was stipulated to.
And are my recollection is you're only contesting the car to the adult daughter.
Correct.
Why
And
not the son?
I didn't see where the son was given a vehicle.
There was another vehicle. Well, whatever. We'll look at the record, but my understanding is that there was another vehicle as well.
And if that's
And it
the
was
case,
given to
Your
the
Honor,
son.
my position doesn't change. The court didn't have jurisdiction to give either adult child any of the marital property.
Counsel, were the stipulations submitted in writing to the trial court as an exhibit?
No, Your Honor. At the beginning of the trial, the judge put the stipulations on the record, and then we went on to try the issues that were not resolved and stipulated to.
Thank you.
So the stipulations would be in the front part of the transcript. And then our last issue was innocent in the transcript. My client accepted $4,500 less from his 401k to satisfy an amount he said she owed him in property division. And then when they did the new order, they're saying now that she needs to pay him that. That is not supported by the transcript, and we're asking that those provisions are reversed and sent back to the trial court. I reserve my 5 minutes if there are no other questions from this.
Seeing no question, thank you.
Thank you.
You have your full 5 minutes for rebuttal. Mr. Gormley, please come forward.
Good morning, Your Honors. I am the appellee, Darryl Gormley, in this divorce matter. The parties resolved all marital assets and issues in the divorce matter prior to trial, with any further resolutions reached the morning of trial with the judge's assistance. Those stipulations, as the court was discussing earlier, were read into the record, and they were later reduced to judgment by this trial judge. As indicated in the judgment entry that was filed on 11/20.
When they were read into the record, and again, I'm not seeing it, I'll review the transcript. Did the trial court confirm of each of the parties that that's what's their agreement, that's what they wanted to do, make sure that they understood the agreement. And
That is correct.
each party assented and said, yes, this is our agreement, we're asking the court to.
That is correct, Your Honor. The judge, when we went through all this, it was read as to what was happening with the vehicles, with the money situation, everything. The party asked if it was knowingly and willingly entered into. All the parties said yes, the attorneys were present, and the court eventually reduced it to judgment as the final entry. So this was all stipulated to before.
And at that point in time, no one objected to adult children or anyone who was not a party receiving any property.
Correct, there was no objection. As indicated in the judgment entry that was issued by this court, which was the amended judgment entry on November 25th, 24, the court found that the division of the properties and debts were presented knowingly and voluntarily entered into the parties, with each party affirming same. The only issue that went to trial was the spousal support. Yet appellant attempts to raise two assignments of errors related to those voluntary and knowingly entered agreements, which are issues 2 and 3, which we were briefly discussing with the appellant. They were coming up with the two, which is the first one is, which can easily overruled if you check out the transcript. It is clear that the appellant agreed to allow the party's daughter to receive the Nissan Sentra. This is indicated in trial transcript page 7, lines 1 through 2. It is also clear in the trial transcript that the appellant agreed that she owed $4,545 to the appellee. This was the difference between the motor vehicles. The appellant was keeping a newer vehicle that had a bunch of equity in it, and the appellee was receiving a 2011 car that had like 160,000 miles on it. So this discussion occurred, it was agreed to and stipulated to, which advised to the court and was read into the record. This is located on trial transcript page 6, lines 18 through 25. Further, it is clear that the $4,545 for the car difference was not credited against appellee's 401k. This is fully demonstrated in the merit brief that's filed by the appellee. It is also further indicated in the judgment's judgment entry, which required the appellant to pay the $4,545 to the appellee within 30 days of the judgment entry. So the calculation for the $4,545 was never credited. That is still owed to the appellee and has not been paid. And the parties did agree for the daughter to receive the motor vehicle, and the court can award that. The appellant filed no reply brief in support of the merit brief that was filed by the appellee to rebut those calculations. When the parties enter into a settlement agreement in the presence of the court, such an agreement constitutes a binding agreement. This is cited in Walther versus Walther. It's a 1995, 102 Ohio Appellate 3D 378 case. Therefore, assignments of error 2 and 3 can be easily overruled, as the court did not abuse its discretion and a binding settlement was reached, which was later reduced to judgment. The only issue that went to trial was the spousal support. After hearing testimony, the court awarded the appellant $250 a month, payable until appellee retires, which is age 67. That's approximately 12 to 13 years out. The trial court went beyond the normal 1-for-3 ratio, 3 years marriage for every 1 year of spousal support. Had it done so, the court would have only issued around 7 years of spousal support. But the judge in this case elected to go 12 years out and awarded a longer time period for the $250 to occur.
The court has retained jurisdiction to modify, has the court not?
The court did.
So the court could, if you were to retire the court at some point in time before 67, you could ask for modification. The court could order a modification.
It would not, actually it's full retirement, so my full retirement age is 67, so I would not be able to modify it under that scenario.
Well, the court accepted jurisdiction to modify, and you could ask the court to modify. The court may say no, but
Yeah.
you can ask.
I can ask her to modify for other substantial reasons. Obviously, we all, the death, cohabitation, and so forth as well. But the way the JE is written as it stands, I have to really wait till 67. So it would have to be a substantial change in financials, I think, for me to go back in and change that number. This court does review the spousal support, as you know, under the abuse of discretion. And abuse of discretion is an arbitrary, unreasonable, and unconscionable standard. It's a very high standard with this court. The trial judge got to hear all the testimony, got to look at the competence, got to look at the credibility of the witnesses when issuing her decision. The goal of support is to reach an equitable result. This is cited by Carolee versus Carolee, which is cited in the merit brief. While there is no set mathematical formula to reach this goal, the court must consider all of the factors outlined in Revised Code 3105.18c, not base its determination upon any one of those factors taken into isolation. What it appears that the appellant's trying to do is take one thing in isolation, which is the income only, and saying that you have to equalize the parties' income to make this a fair resolution. And that is not the case here. And I'll go through some of the details to explain why. There are actually 14 factors under the Ohio Revised Code that the judge looked at. If you look at the judgment entry the court laid out, she not only cites the statute, she goes out and finds findings of fact that pretty much lock into almost each and every one of those statutory requirements to be looked at. Some of those requirements are obviously the income of parties from all sources, the relative earning abilities of the parties.
And it seemed to me the trial court was basically saying that you make roughly $120,000 and Ms. Gillies now makes approximately $83,000. Is that about right for the income?
Well, the court, that was some of the W-2 information that was provided to the court. The appellant was earning just under, I think, 90 for the calendar year of 2023. And then my income without my medicals that was provided by the client was right around 121 was the testimony that was provided by the court. Those were the raw numbers on just those two incomes. But
And in your brief, you talked about the fact that you have a lot more expenses than that, essentially than Ms. Gillies does. Was that evidence submitted to the trial court in any way, shape, or form?
the expenses we went through, there was some testimony about the expenses that I had that were related. The appellant didn't provide any testimony at all as to her expenses or the requirements needed for spousal support. If you go back and look at the thing, there was no testimony given by the appellant. The appellant's testimony was basically just the amount she earned.
And the trial court didn't make any finding about what your expenses were and how that played into what the trial court was
The
ordering.
court did not. The court did not put that in their judgment entry. The appellant in this case provided no opening, no closing, and gave no testimony at trial as to what amount of spousal support should be given. If you look at the transcript, you will see there was no request at trial as to what amount she believed was deemed necessary for spousal support. She also provided no testimony at trial as to what her expenses were and to what is required to maintain any type of standard of living. So she was leaving it up to the judge to go through the standard under the statute to determine what amount is sufficient for her under the spousal support. Of more significance in this case is that appellant failed to transfer the entire record. Both this appellate court, through a magistrate's order, required him to provide a full transcript of the proceedings, and appellee, myself, filed a motion to dismiss to this court that the record is not complete because it failed to include all of the introduced exhibits that were admitted into evidence at trial. It is the appellant's responsibility to transfer the entire record to the court in order for the court to determine, for this court to look at it for spousal support. This appellate court advised the appellee to go ahead and take care of this issue in its merit brief, and that's what it had done. If you check the merit brief, we went through the issue of the failure of the complete record in front of this court. So by failing to provide the documents that are admitted into evidence, this court is missing the following. Defendant's Trial Exhibit A, which is the parties' 2020 tax returns with both parties' W-2s. Defendant's Trial Exhibit B, parties' 2021 tax returns with both parties' W-2s, including Lowe's 2021 W-2. Defendant's Trial Exhibit C, which is the parties' 2022 tax returns with both parties' W-2s. Defendant's Trial Exhibit D, which is appellee's 2023 pay stubs. Defendant's Trial Exhibit E, which is appellant wife's pay stubs for Akron Public Schools, including her Lowe's W-2s for 3 consecutive years. And Defendant's Trial Exhibit F, which is appellant wife's increased salary contracts and supplemental contracts for multiple years. There were also some additional exhibits admitted by the plaintiff, which were also not part of this appellate record. So this appellate record is missing all of the financials that were at times discussed during the case, were presented to the trial judge, and the trial judge would have had in her possession when she's rendering her decision. Without a complete and adequate record, this court should defer to the trial court's findings and judgment. That is a citing in J. Norman Stark Company LPA versus Dahl. Another case talks without the complete and adequate record, this court must presume the validity and regularity of the trial proceedings and affirm the trial court's judgment. And that is citing Richard versus Carmax. Where a party in an appeal fails to file portions of the transcript necessary for resolution of her assignments of error, the assignments will be overruled, cited by the court.
How is it relevant to the factors that wife Ms. Gillies had a loan that's since been forgiven? I understand looking at a liability as part of the statute, but how is the forgiveness of a liability that she doesn't have to pay? How's that relevant?
I'll review that in the statute. The reason some of the other evidence is impertinent is with tax returns and the W-2s, it shows all of the income that was owed for the clients over the last 3 years and their deductions. It'll show the benefits that each party received. If you look at the merit brief, and I'm going to discuss further after I answer your other question, she has benefits from the school system that are about $40,000. With her salary and benefits, she has actually a valuation that exceeds what my salary and benefits are for my.
Did the trial court make any finding about these benefits?
The court did. There's testimony from me that went through each and every one of her.
We're talking about the
benefits.
findings of the court. Did
The
the
court
court
did-
abuse
the court-
discretion by looking at the
The
findings?
court did not address her total benefits. The court addressed my benefits when it was talking about inclusion of my medical paid by my client, my employer, which was around $5,000 or $6,000. So what appellant was doing was trying to have the court increase my salary because of the medical payments paid by my employer. But the appellant didn't want the court to look at the fact that the appellant was receiving $40,000 in benefits from the Akron Public School Systems. So it is in the record. The court had it it wouldn't have been in the W-2s, but the court had it through the testimony, and it's in her W-2s, on her W-2s, which shows the expenses that were being paid by Akron Public Schools.
And the W-2s are some of the exhibits that we do have.
Those are exhibits you do not have in front of you.
We do not have.
You do not.
Okay.
So the issue on the student loans, beyond just the income potential issue with the forgiveness, under the statute that's provided, which is required for the judge to look at, it actually meets several other thresholds for relevancy as to the student loans. The student loans amounts that were incurred, that were testified by the appellant, was about $600 a month. And that was like the minimum payment that was being paid. When you extrapolate that amount over the duration of the marriage, we're looking at about $165,000 made in payments out of the student loans. And those payments were made out of the marital assets.
Were they actually made or were they forgiven?
No, these were payments that were made throughout the marriage. The forgiveness occurred after the divorce.
Okay, just want to make sure I understand what you're
Yeah.
talking
So the student loans itself has a bearing on the case. It did affect the standard of living. And it also was forgiven, which does have the effect that she no longer is responsible for that debt. If you look at the statute that are required by the judge, there's several things that come up that are related to these student loans. The student standard of living established during the marriage is supposed to be looked at. That's one of them. The relative assets and liabilities of the parties. She no longer has that as a liability. So
I understand appellant's argument to be that the court considered that as income.
The court does not really, it doesn't really specifically show that it calculated and gave a total as it being included as income. And I think the court can see that in the judgment entry. But then the other statutory section, which is applicable to the student loan, is the court is supposed to look at the contribution of each party to the education, training, or earning ability of the other, including but not limited to the party's contribution to the acquisition of a professional degree during the marriage. So as the appellee, I had helped contributed to the payment of her obtaining the master's degree that was obtained during the marriage. And that is something that the court can look at.
And was there evidence submitted about whether or not there was any contribution from her to you receiving your degrees during the marriage?
There was none. No. So in this situation, both the appellant and the appellees are professionals. Appellee is an at-will associate attorney at a creditor's rights law firm, receiving one raise back in 2022. His appellee's salary was reduced 25% during COVID for approximately 2 years, and it remained stagnant for approximately 5 to 7 years.
About a minute left in your time.
What's it?
About a minute left in your time.
Appellant is a tenured contractual employee with the school system, earning approximately $90,000 a year. The benefits that the appellant receives is about $40,000 a year from the Akron Public School System, including medical, dental, vision, and full contributions to STRS. When you add up her salary and her benefits, it's about $130,000 a year, which exceeds that of the appellee. In addition to that, the appellant had a second job with Lowe's that she retained for 3 years, earning approximately $10,000 each year. So when you add that into the mix, her salary plus benefits.
Did she stop that job prior to trial?
She stopped it right before trial. Correct. So the marital assets were used to pay back the student loans, and the student loans were eventually forgiven. But the court is looking under each and every one of the findings of fact that are provided to that to give it some context with the student loans. There's actually a case, I believe, in the 9th District that's on.
Sir, your time is up. You can briefly conclude.
Okay. Your Honors, we would ask the court to affirm in total the decision issued by the trial judge in this divorce matter.
Thank you.
Thank you.
Thank you. Again, if you review the transcript, you will not find any testimony, exhibits, or evidence that the appellant received $40,000 in benefits from Akron Public Schools. The appellee says that she get full contributions to STRS. That contradicts the testimony in the transcript. In fact, the transcript says she paid from her salary $12,215 a year. So there is no full benefits. Now, the appellee just argued that the court should have subtracted $4,000 from his $25,000 for insurance benefits. The testimony at the trial, during the marriage, his insurance benefits was paid by Akron Public Schools. He was on appellant's insurance until they got in divorce, and he had to get insurance for himself. So no, he shouldn't get that. What is true, and we know in this court, is that STRS contributions is mandatory. She can't change that whatsoever. That is not a disposable income, in no way, form, or fashion. As it relates to the car of the adult children, the reason we know there was no agreement, in the first judgment entry by the court, it was not mentioned whatsoever, because there was not an agreement. It's not in the transcript. The cars for these adult children shows up in the second judgment entry after the Court of Appeals sent it back to the trial court. But in the initial judgment entry, there's no writing or anything about those cars, because that was not the agreement. The case law says it's to be assumed that each party contributed to the income and the income ability of the family. Is undisputed that my client, that the appellee testified during trial, there was times during the marriage that my client stayed home, didn't work, took care of the children. That allowed him to climb the ladder of an attorney while she stayed home. They didn't have to pay child care because she was there. There was testimony that she did work at Lowe's before the divorce, but there was no testimony that she didn't use the extra money from Lowe's to pay her student loan payments. Now, he argues that he made contributions, but there was no testimony. He argues about the some of his money was to pay the loan back and some was forgiven. There was no testimony at the trial how much money they paid for loans and how much was forgiven. So he's asking this court now to maybe pick a number out of the air, out of your head, to figure out how much we paid and how much was forgiven. Again, a forgiven student loan is not paid for by either party. It's paid by us, the taxpayers. It's not income because the law allowed the government to forgive this loan. If you look at the transcript, when we went into the trial, he was arguing that he needed money for equity in those cars that the children was driving. My client says, no problem, let's sell them. After some conversation with his attorney, he withdrew his claim. There was never any agreement to give the kids the cars. In fact, the car for the younger child, there was still payments on it. There was no way for the court to give a car to somebody where there's a payment unless the bank approved, unless she qualified for the loan. Didn't happen. Everybody knew that my client was paying money on that car that her daughter was driving in her name, but she's paying. So there's nothing in the transcript that support appellee's argument that they agreed for the court to give the cars. Wasn't even possible. There was still payments to be made on the car. Again, the court lost its way. It's only about 25 years, but I've never seen a court discuss student loan payments as part of income, as part of the calculation for spouse support. Never heard a court in 25 years talk about because a family couldn't go on vacation, we're going to consider that for spouse support. There's no case law, no statutory law to support those things. If that's what somebody won't have to go down to Columbus. You don't go to the court and have the court do it. You got to go to Columbus. Court's lost its way, lost its discretion. We ask that the court would reverse these decisions and send it back to the trial court. Thank you for your time.
Thank you, Mr. Tyler. The court will take the matter under advisement and issue a decision in due course. When that decision is reached, it will be mailed to you by the clerk of courts and also be available on the High Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your presentation today.